friends. Hello, hello. Hi. Mhm. Okay. Hi, everyone. This is Marina Shepelsky. Hello, Instagram. Hi, this is Marina Shepelsky. Today, we will talk about U.S. immigration news, and we will talk about what happened this week in the world of immigration news, what's new, what's exciting. Drop your questions in the comments. I will answer them at the end of my news. So we'll just be saying hello. My friend Manish says, hi, madam, on YouTube. If you're watching me on YouTube and on Facebook, hi, friends. If you're watching me on Instagram, welcome, welcome. I'm happy to be with you, as I try to do every Wednesday at 11 o'clock New York time, Eastern. So the federal judge yesterday said that the third country transit ban for people who are filing for asylum and they passed through third countries, automatically banning people from asking for asylum when they passed through third countries on the way to United States, is illegal. And for now, until the matter is decided in detail, they put a freeze on it. So it's called a restraining order. So the third country transit ban, it's been many times that immigration has tried to use it as almost an automatic ban on filing for asylum since Title 42 ended, and that was just recently in May. That's what USCIS and ICE have been using to deny people, saying, look, you passed through third countries, you had a right to stay there, and you didn't stay there, so we're not going to give you asylum. Go back to your lovely country, right? And organizations have brought this to court. They said, we're going to sue you. This is illegal. You shouldn't be using this. And it started, of course, to be seriously used under Trump. But then COVID happened and they switched to Title 42. And now the rule is back, and people took they took Department of Homeland Security to court. So the federal judge said, look, I'm looking at this. It doesn't look right. For now, you have to freeze it until we have a full court hearing. And I'm going to tell you right now more details about it. Just wanted to look it up because I don't remember which can create a specific judge. I have the name here. The judge. So Reuters, the article by Reuters says that on July 25th, a U.S. federal judge in California. This was in California. Californian-based U.S. District Judge John T. Garr stayed the order for 14 days, leaving the restrictions in place for now, but saying that it should be blocked, that the third ban should be blocked, and it's not right that it's used. So that was in the news yesterday, and it was a big deal. And this was really mostly used at the U.S.-Mexican border to not let people enter at the border. But now they're applying online because under the current situation, right now, people apply on their phones, through their smartphones, through the CBP One app for asylum. And basically, the government says if you had a chance to get asylum in another country that you pass through, even Mexico sometimes. And this and it was in effect under Trump. Then the COVID hit, that kind of disappeared. Since COVID ended, they brought it back. It's been in effect for 2 months. And the judge says this rule cannot remain in place. And this order that he signed is going to start working in 2 weeks. So people applying 2 weeks from now and later will already be temporarily not subject to the third country transit ban. And the Justice Department is appealing this, so we'll see where this goes. But for now, for today, this is good news. And I wanted to tell you, it was the American Civil Liberties Union, ACLU, that took the government to court. So that is really important news. I wanted to be very clear about that. On the USCIS front, if anybody has a pending F1 student visa change of status, don't forget now you can expedite your student visa, but it will cost you, and it's going to cost you $1,750. But in a way, for people who can afford it, this is a really good thing to have, because I had a consultation yesterday for a man who is considering applying for an employment green card. But of course, you cannot wait in the United States for that if you don't have status. He applied from a tourist visa to change to an F1 student visa. He's been waiting since April. I said, look, this new rule says now we can file to expedite the decision for you. It's going to cost you $1,750. It doesn't mean they will approve it. It only means they will make a decision quickly. Now, we don't know. I said to him, look, on the one hand, it's a good thing. On the other hand, if you don't expedite, and right now the processing time for change of status from tourist to student or whatever, non-immigrant change of status takes a year for him. It's in Nebraska, right? It's not a bad idea to take that time. You are in status right now, you're pending, to kind of get your case for the employment green card together and go ahead and file. So we'll see what happens. But that's in the news, that if you have a pending change of non-immigrant status, you can file for a fast decision, expedited, and the fee is $1,750. Now, you can also expedite other petitions, usually work green card petitions, that cost more. Also, it's important to know that in August, all the categories for many cases retrogressed. If you have an approved I-140 petition, employment immigrant visa petition, sometimes you will have to wait for up to a year to file for a green card. If that's the case, and we're working with employment visas also right now a lot, in addition to VAWA, abuse cases in the marriage, VAWA, abuse by a child over 21 who is a U.S. citizen, asylum, waivers, we do that kind of work. But right now we also do a lot of employment work. So we are filing for work permits for people who are here in work visas, got an approved work green card petition, but because of the retrogression in the visa bulletin, the visa is not current for them, so they can't file for a green card just yet. They have to wait. We're filing for work permits for them in the compelling circumstances C35 category. You know, this is only for those people who got the employment visas. For the rest of you, it's just news, I'm sure. USCIS is about to publish a revised, a new updated Form I-9 for employment eligibility verification, which means when you're hiring as an employer, as a company, when a company is hiring somebody and they want to check his status, there's a special form that you have to fill out, and then they submit it to USCIS, and the form is updated. It's a new form. Also, they recently updated for people who have a green card filing for U.S. citizenship with a disability, the N648 disability waiver form, N648, has been updated and simplified in some ways. So that's really good news, although it's not like new news, but for many people, they're still finding out about it. Also, I have to record a whole video about this. I haven't done it yet, but there's been updates about who USCIS will consider to be a public charge. This whole thing with public charge only comes up when family members are filing for family members, and they have to prove that the affidavit of support is enough to support the relative you're bringing in, the beneficiary, but also the beneficiary has to prove that they're not gonna like sit on the necks of the taxpayers, you know? So they updated the policy manual. By the way, for many people, it's a surprise to know that USCIS has a special policy manual. What does that mean? It's like a Bible, like a step-by-step instruction for the officers of USCIS, telling them how to decide different kind of cases, how to look at the paperwork, what to say, and it's like a checklist for them. It's written out in words, but essentially, it's a checklist for USCIS officers to make decisions on certain things. For example, public charge. For example, employment immigrant petition. For example, VAWA. For example, asylum application. And we have a right to look at it and read it just like they do. We make them uphold it because this is interpretation of the laws in a how-to guide. Really, that's what it is. And that's called the policy manual. You can find it at their website. It's absolutely free. You can read it. And they updated this chapter 3 for public charge. And they said that applicants for adjustment of status, meaning green card through family, the way they determine that, the way they make that decision if somebody is going to be a public charge, of course, they look at the affidavit of support and so on, is a little bit updated. So here it is. If you're interested, you can take a look. I have a comment from Porfirio Diaz who says, I'm best attorney, very humble, and señorita hermosa, which is beautiful in Spanish. Oh my God, you guys, I have to tell you, thank you so much, Mr. Diaz. Thank you for posting. Here's the question about the public charge. We'll get there in a minute. Ihsan says hi. So the funny thing is, I really want to get Spanish-speaking clients because I love immigration work and I love to do it for people from all over the world. We don't have that many Latino clients right now. I would love to get them. They're the best clients. They're so grateful. They're so nice. And I feel like in their lives, I can really make a difference. So me and a Spanish-speaking guy at my office, Dimitri, who is like me, born in Ukraine, but he is fluent in Spanish, we recorded a really funny video, one minute, only 1 minute yesterday. So my team is gonna like edit it and they're gonna post it on Instagram. So guys, follow me on Shepelsky.attorney on Instagram. Soon you will see my video in Spanish. I don't say much in Spanish. I say only soy es Marina Shepelsky, soy es abogada de inmigración of United States. That's all I say, and then I give him the microphone. He's the one who says what kind of cases we do in Spanish. So guys, we have a Spanish-speaking person in the office. We're about to hire 1 or even 2 more. So please, if you have friends or family who speak Spanish, send them our way. The cases are the same for everyone, guys, whether it's a T visa. For example, if you or somebody you know has been a victim, or we call it trafficking, right? So you were either forced to have sexual relations against your will and they took advantage of you because you are an illegal or undocumented immigrant, or work. Like if you worked for less money than the minimum wage in some place and they held your immigrant status over your head, that's a T visa. That's labor trafficking. Yes, under the regulations, you can get a T visa and then a green card based on that. I have a couple of Latino cases right now based on that. T visas are amazing. So, you know, again, we speak Spanish at our office. Don't worry, give us a call. The law is the same, whether you're from Pakistan or Bangladesh or Ghana or Nigeria or Ukraine or Russia or Guatemala, Honduras. There's different things for different countries, of course, but the law is the same for everyone. So please don't be afraid, and you'll see this funny video soon. I was laughing and making fun of myself, of course, so much yesterday. Sometimes I go to work to have fun. Okay, now more news from USCIS, and then we'll end the news part, and I'll get right to your questions. I know you guys want me to answer. Oh, okay, they said something about expanding. So USCIS expands the My Progress to form I-765 and form I-131 for advanced parole. What does that mean? My Progress is like a little program on their website that provides applicants with access in their online account to personalized estimates of their wait time. So now, if you filed online for I-765 or I-135, or you open this My USCIS account, now you'll be able to see personally to you how long you have to wait. But actually, I'm telling you, and I've been teaching you guys now for the longest time how to check how long you have to wait. You look at your receipt notice for your work permit or advanced parole or anything else. You know the form number. You look on the bottom left corner for which service center is handling it. You go to uscis.gov, processing times, and you look up the average time. Question on Instagram from Olympia Kiss. Question from Sarfaz. Is it possible to expedite the request for siblings? The I-130 file for a brother or sister was submitted in 2017. Thank you. Unfortunately, there's no way to expedite the visa categories for the relative petitions. You have to wait. Right now, it's like 16 years for a brother or sister. I mean, yes, okay. I shouldn't say it 100% of the time. There's no way to expedite. Sometimes there is, but you really have to have a life or death. Like somebody's dying, God forbid, cancer, something like that. That's the only way to try to expedite. If it's just a regular life situation, it's hard to wait, whatever. Right into the questions. Keto TV says, "Hi Marina, you look beautiful as usual." Thank you so much. Quick question: how long will it take for work permit after having my fingerprints done for VAWA? If you filed for VAWA alone, no green card application, no I-485, either in progress or filed with VAWA. The VAWA-based work authorization takes the same as your VAWA. So the minute your VAWA is approved, it might take 2 years, up to 34 months. That's the official processing time just now. That might take 34 months. It might take only 2 years. You will get the work permit and the social. By the way, in one of my groups today, somebody asked a question. They have VAWA approved. They got the work permit, but the social hasn't come. And then they went in person to the Social Security office and they said the alien number is not yet in the system of the Social Security Administration, which tells us how this works. When you file for VAWA or I-765 work authorization application, you put in the request into the system. As soon as your work permit is approved, the data information, internally by the computer to the Social Security Administration to assign a new social to you. Sometimes it works 99% of the time, but once in a while there's a mistake and they don't send it. Just be patient. Sometimes it takes longer. It takes 2, 3, 4 weeks and a couple of months. But the bottom line is your question was how long for the work permit for VAWA? Between 2 years to 34 months. Ustaz Majid says, "Hi, how to transfer cases to a different country after DQ to get rid of backlog in my country. Is it okay?" If you have a right to live legally in another country, yes, you can transfer. You can request that NVC transfer your case for the interview track in a different country. They will probably even give you a new receipt number for NVC, a new case number for National Visa Center. You have to have a reason for it and like have a right to live in that country. And yes, then you will avoid the backlog. Manish says, in a VAWA case, if I have a travel document, can I travel in the world anywhere? Yes, you can, as long as your VAWA is active, as long as your green card application is active, as long as it's not denied, it's in good condition, you can travel. If you don't have arrests, you can travel. Okay? So you're good to travel if you don't have arrest and your VAWA, your I-485 are still like active. Of course, if VAWA is approved, yes, you can travel. Okay, so Goon says, good morning, ma'am. Will you please explain the EB2 process from start to end? The next step after the PWG process is completed. Thank you so much for asking. Um, Here we go. So let's talk about the EB2 process. The EB2 is usually when people get an employment immigrant visa or petition, and it's based on two things, right? So it could be, so there's really two categories, two main divisions, main kinds of EB2. EB2 number one is you have an advanced degree. Usually that means you have like a bachelor's plus 5 years of post bachelor experience or a master's degree. A master's degree is also good, right? For that, you will need to show your official diploma, your official academic transcript with the hours you completed, and proof of your 5 years of employment if it was in the same area that you're working in, right? 5 years employment. Uh, that's the number one type. The number two type of EB2 is when you show exceptional ability, and there you also will need to show that you have advanced degree, plus the three criteria that you have, like official advanced degree, letters from employers, license to practice your profession, evidence that you commanded a high salary, membership in a professional association, recognition of your achievements, like articles about you, awards, high compensation, anything to prove you made a significant contribution to the industry, and other kinds of evidence. Now, you will need like a general labor certification, which means you first have to do a prevailing wage determination. Yes, absolutely. And then you will be asking for a waiver of the what's called national interest waiver of the labor certification, the way the full process of it is concerned. So your question is, what is the next step after the prevailing wage process? Then after the prevailing wage determined, you prepare ETA, labor forms, labor department forms. You work on the company letter. You gather all the evidence that you have the advanced degree, that you have the experience, contracts, invoices with your employers, recommendation letters from high-level professionals in your field. You get all of that together and you put together the I-140 package and you send it out. If you do uh, premium processing, expedited, you could get an answer within 2 weeks. That doesn't mean then that you can immediately get the green card. As a matter of fact, this is what I was talking about earlier in the show, the retrogress. So the so if you file like in the next 2 weeks, then you will get a filing date of maybe August. I looked at the August 2023 visa bulletin, and it depends where you're from. I don't know what country you're from, and this is not any kind of legal advice, obviously. We're just talking generally. But for EB2, the third preference, I'm sorry, the second preference you asked me, the second preference, they're now working on April 2022, which means you will have to wait about a year from the date you can file for green card and has to be in status. But you should get a decision on your EB2 petition if you filed for premium processing for expedited very quickly, 2 weeks to get the decision. But this is like a multi-step process. Good luck. Thank you for asking. It's a really good question. Keto TV says, how long will VAWA prima facie approval take after applying for VAWA? If you submitted everything in the same package, that means proof of the marriage, even a little bit, a short story, proof of the abuse, and criminal background checks, you should get the prima facie within 3-4 weeks from filing. The prima facie approval for people who file for VAWA is like a sort of a preliminary pre-approval. It mean your case will ultimately be approved, but it's a letter you can use to go get Medicaid, food stamps, and so on. Sargun says, how long does the EB2 process take today? As I said, premium processing, 2 3 weeks. Regular processing, 4 or 5 months at most. Then you need to wait for the green card to be available. That could take another year and a half. So give yourself like a good year and a half for this. And that means you either wait in the home country or you got to be here in America on a non-immigrant visa in status this entire time until the visa becomes current for you and you can file for a green card if you're here. Porphyria says best attorney. Oh, thank you so much. Marina says, will the fact of having food stamps and Medicaid before marriage with citizen affect my chances of getting a green card? How to answer this public charge questions in I-45? You have to be honest about it. The fact that you had them before is probably not going to affect it, to be honest with you. Because if somebody is sick and they get Medicaid, it usually isn't a big deal. You should always be honest in the form. That's how I can tell you to answer. Iksan says, how are you? I'm great. Thank you for asking. Asif says, any updates on the I-601 waiver? I've been waiting for 3 years to ask my attorney, can he cancel removal? But my attorney said, no, you have to wait. I agree with your attorney. It takes up to 3.5 years now. Katerina says, how to apply for green card through marriage for me and my daughter, all the forms together by mail or her separately, or that into the online and everything after mail. Give us a call, 718-769-6352. I will tell you during a consultation. Thank you so much. Farah says, good morning, Marina. Hope you're doing great. Is it possible to expedite the I-130 for married son of your citizen child case? So right now, I'm going to share my screen so I can show you how long the married child, if U.S. citizen child, will take in August, right? As I said, all the dates have retrogressed, which means they're not expediting at all right now. So the married child of U.S. citizen is category F3, F3 right here, and they're currently working if you are from anywhere in the world, pretty much except for Philippines and Mexico. On January 2009, which means it's a 14-year wait, and there's really no way to expedite it, but everybody is, worried about it and asks. There's no way to expedite it. It's going to take about 14 years. Christofina says, I filed for VAWA and USCIS received it June 10th, but no receipt number yet. Sometimes it takes 6 weeks. If you already have an alien number, in 2 weeks from now, if you still have nothing, give them a call. Ask them to track down your VAWA based on your alien number. Like your alien number, if you have one, they can track it down. If not, and you get nothing back from them, and it's like another 2 3 weeks, maybe just resubmit it again. Sometimes they just don't get it in time, or they lose it. But right now, it's too early to say. Just give it another 2 weeks. Maybe it's still going to come. Ali says, hi, is there any updates about undocumented immigration plan, the Dignity Act? No updates, Ashley. No updates about the Dignity Act. Instagram question. My mom applied, and this is from Hassan Bid. My mom applied for the F2B category, which is single green card holder kids. Kids or green card holders for single adults. So my mom applied F2B in October 2019, approved 3 years ago. My VAWA is pending violent removal procedure. So your mom's petition is not going to help you at all for your removal proceedings for your court. It's not going to be, ripe. You're not going to get a visa through that for a while. Let's put your mom's thing aside. VAWA is going to help you. With the VAWA petition pending, you could either ask the court, your immigration judge, to close and cancel your case, which is called dismiss or terminate, or pause it, put it on freezer right now. That's called administrative closure. So that will affect it. And if you get approved, then you tell the court you're asking them to completely cancel or dismiss the case, and you probably will be dismissed unless there's, criminal stuff. Hassan says, can a K1 visa, a fiance visa holder, married to another person after divorce or first marriage, you can do whatever you want, but it's not going to help you get a visa or a green card. Anthony Sennett says, hello, Marina. This is from Instagram. Anthony from Instagram. Hi, Marina. My I-360 VAWA got approved. Oh, I'm sorry, not VAWA. My I-360 R1 religious worker visa got approved. An R1 clergy. My employer filed for a green card for the next day. Still status. Hope this is okay. Yes, it's fine. Everything is correct. Official Malta Me Preet wants to know how many requirements for my VAWA kit. Let's go over VAWA. I'm glad you're asking really good questions. Thank you so much. Number one requirement, prove that you lived in this marriage and you became married for love and to create a family together. How do we prove this? Letters from witnesses, bills in two names, tax returns in two names, bank account together, joint bank account, bank statements to show you had activity in it. It wasn't just the statements. You use this account, you charge things, you spend things, and you gain things together. Trips together, photos, things like that. Number two requirement, abuse happens. Some people have police reports, some people don't. It's not required. Some people have a restraining order, some people don't. You have to show you went to a psychologist. There's nothing stopping you from going right now. Go to a psychologist, get a letter from a psychologist. Letters from witnesses, your parents, your friends, your neighbors, your coworkers. They can say they saw something, they heard you cry, they saw that you were upset, you complained, you explained, you shared. This is all proofs of abuse. The third part of VAWA, you asked how many required? Three. One is the joint marriage to abuse. Three is good moral character. One, police clearances. We usually do your fingerprints right in our office and send it to FBI to get a clearance. Two, if you have, as part of that, a good moral character, maybe you go to, a mosque or a church or synagogue or community center. You volunteer. You help a family member. You're taking care of your ex's kids. Whatever it is that you do that shows you to be a good moral person, get letters, get paperwork to prove you are. All right, let's move on. Andrew says, my boyfriend brings me here. It's not Andrew, it's Andrew. My boyfriend brought me here, and after that, he used me as a home servant, worked for him without paying him uncountable business, and applied for two visa. I've been here more than 15 years and have two kids. Absolutely, Andrew. Please give us a call. We have a very similar case to yours right this minute in my office. We already sent it out. You're absolutely eligible for the visa, T visa. So, 769-6352. We can help you apply for a T visa. Thank you for asking other people out there. Listen to me. If you were like forced to work for anybody, a boyfriend, a family member, a stranger. I have a client now who works for a bakery and they like forced you to do this work against your will. That is considered trafficking. We'll take care of that. This is what we can get you a visa, and it's not even that hard like you think. Alejandra, uh, Alejandra Pereira says, thank you for caring for our Hispanic community. I care so much, you guys, and I want to learn Spanish. I'm trying right now. Believe me, I'm trying, but if I had the chance to go live somewhere, any Latin American country, of course I would pick up the language. I'm pretty good with languages. But I'm just working all the time, so it's not so easy. El Cupa, or El Tipa, I'm sorry, El Tipa is my team. Our team habla español. Shireen Malcolm says, good morning. I applied for a U visa in December 2021. You know what year they're now issuing? 5 years they're taking for U visas. Let me just tell you for sure. U visa processing time. And guys, you can look this up yourselves. USCIS.gov. Processing times. Case processing times. I go to, for U visas, I-918. I-918 18, petition for non-citizen who is a victim of criminal activity or witness. Nebraska, 60 months, 5 years for U visa. Okay, 5 years for a U visa. Madam, I'd like your instruction regularly and wait for your new speeches. Now, thank you so much. Fluffy says, hi, attorney, the best picture. Adus Abubakir says, my spouse, Charles, good morning. Hi, good morning. Fluffy says, I would like to ask a question. If the petitioner died, is there any chance it has to wait 2018 and 19? Let it was approved for the petition, but only now we're starting, I guess only now the visa is current. Give us a call for a consultation. Sometimes, if you have a relative, like a brother or sister, do a humanitarian substitution, you can help, but sometimes if they died before the approval of the petition, unfortunately not. So give us a call, we can do consultation. Phone number 718-769-6352. Stephen Jin says, is there no more PD administrative closure? Who told you this? We do this every day. Yes, there's very much a PD administrative closure. Last night, I downloaded the most recent meeting between us, VAWA, immigration lawyers, and ICE and the litigation department of ICE about this PDs, the latest developments. I haven't had a chance to read it yet, you guys. This is literally at like 9 last night that I downloaded it. And today I was busy preparing for my show with you. I didn't read them yet. As soon as I do, I'm going to talk about what I learned. Yes, it's a thing. This, I do this every day. Stephen says he has a case of the immigration court and wants to close it. And I still have my EAG card after the asylum case. Two parts of it. If you want to close it, only if you have a reason to close it, then they will close it. Yes, you can do PD, but you gotta get the government to agree and you gotta give them a reason. You can't just close it. For example, Stephen, if you have a kid who's gonna turn 21, or you're dating or engaged, you're married to a US citizen, those kinds of reasons, they will administratively close it then. And if you administrative closure, you will probably not get work permit anymore based on asylum. Okay. Fluffy wants to know about the Dignity Act. It has not passed, and I don't have much news about it. Charlie Zoo says, I'm a citizen applying for my wife to submit the I-130 and I-35 at the same time. And so far, I only received the I-130 interview. It's not the I-35 interview. This is what they do sometimes. It's normal. So you will have an interview, and at that time, they will address both the I-130 and the I-35. As manner which documents are necessary for you or you say visa interview time. Not sure what you're asking. And Fluffy said they always watch me live. Andrew says, yes, we can do a T visa for you. Because, well, your case sounds like a very typical, you're not alone, typical T visa situation. I have seen it before. PPP cases, hello, do people need to write a full address of what happened to me in letters of support for asylum? It depends. If you didn't know the address, then no, you don't have to write the full address. You can just say it was in this town, on that street, something like that. Adu says, good morning, Marina Shepelsky. Good morning. Rani Kumar says, good morning, Miss Marina. Good to see you. Stephine Imable says, is there an update on the Dignity Act? No update. Do I think it will become a law? I don't know. To be honest with you, I don't know. I don't have an opinion right now. I would like it to be. Do I think it's going to become a law? It might. It depends. I think it might. There is a chance that it will become a law. Okay. M. Abdul says, when one receives the notice for any country, you will use your previous fingerprints. How long does it take to get into it? Depends where you live. In New York, it takes about 8. You got that letter. If you live in another city, it depends. USCIS, processing time, and then choose the N400 from the list and choose your closest city where the USCIS local office is, and then look what the time there. Rakesh says, hello. I was wondering if my wife can get H-1B. She's a nurse and she's dependent on my asylum for 7 years. Absolutely not. If you're here, asylum pending status, you cannot switch to a work visa. But give us a call. People waiting over 5 years for asylum. If you haven't had an interview, you filed 5 years ago, no court, no interview, nothing, no news for 5 years or more, we are filing writ of mandamus. A court case to get the case moving all over the United States. We are taking the government to court and they will schedule your interview right away. Give us a call. Joyce Doka says, thanks for all you do. Thank you. I already have a social, but waiting for my VAWA decision. How long will it take for my work permit to come? If you file VAWA alone, the work permit will take as long as the VAWA. VAWA is approved, you get your work permit. If you file for VAWA together for the green card, VAWA plus I-485, then it usually takes about 1 year to get the work. Rakesh says, is my daughter, can she get a student visa? She's 17 years old. She's my dependent in my asylum case. Same story. The answer is no, because whoever is waiting for asylum, they're considered out of status. You cannot switch from out of status to a student visa or work visa. Those are both non-immigrant visas. You're an immigrant. You're here permanently already. You asked for asylum. You cannot get the immigrant status switched to non-immigrant. It's not going to work. No. Yasser says, hi, Marina. Is the bona fide determination. This is for the U visa. And the work permit takes 5 years and 1 year after biometrics is confusing. The U visa, that's 5 years. Bona fide determination that will give you your work permit, that might take 2 to 3 years. Those are not confusing, but different. Okay? So just like the people who file for VAWA, while you're waiting, you have a right to get a work permit. Now, how long it takes depends on the kind of case. If you file for U visa, the bona fide determination that will give you the work permit might take 2 or 3 years. The entire U visa case, 60 months. Oh, okay. And Amadou says his N400 interview is in New Jersey. So look, I jump on the website, USCIS.gov, processing times. I'm in the website. I'm going to share my screen so you guys can come on this journey with me. Present screen. Okay, so check case processing time. N400. We choose from the drop-down menu N400. Roll. Next, we put here form category, application for naturalization, and you said you're in Newark, New Jersey. Newark. 60 months. Oh, wow. I'm sorry. 9.5 months. It's updating. Sorry. Do it again. Do it again. Oh, God. They have the worst website. Oh, guys. Newark, N400 in Newark, citizenship, 9.5 months. So from the date you filed, and then give it a few more weeks, like from the date you did biometrics, 9.5 months. Okay. Okay, my last question from Instagram, and I'm outie. I'll see you next week. Okay, last question is from Najem Bilal. How long does it take to get the work permit on asylum case? When we file for asylum, we have to wait 150 days. After 150 days, we file for the work permit. And then it depends where you live, depends who's processing, which service center will be processing your work permit. It might take 1 year, approximately. Some people it takes 4 to 5 months. Some people it takes 13 months. On the average, about give yourself a full year to get the work permit. Look. If I can share my screen with you, here you can see the work permit, how long it does it take. So again, file for asylum, wait 150 days, file for the work permit. File for the work permit, I-765 application for employment authorization. That's the form you file. Then you say based on asylum C08, pending asylum, and let's say Nebraska, 14 and a half months. I'm sorry, not even months to wait. So altogether from the date you filed asylum, about 20 months to get the work authorization. On this note, I'm going to say goodbye. I'm going to say have a great week. I'm going to say have a wonderful weekend. Thank you so much for all of your questions. Thank you for listening. Some of my friends are here every week. I really appreciate it. Thank you so much. I don't take it for granted. I know that I'm not the only attorney, but we super, super care about you guys. We care about you. Give us a call. We can help you. Our phone number is 718-769-6352. And if you miss me between the Wednesdays, find me on TikTok, find me on Instagram, Shepelsky Attorney on Instagram, and Marina Shepelsky on YouTube. New videos are up all the time, shorts. I post instructional videos, and on TikTok. Every day I record something. So I'll see you guys out there, and then I'll see you guys here in the show next week on Wednesday at 11 o'clock Eastern Standard Time. Goodbye. See you next week.